Thanks for joining us tonight, everyone. We'll begin in Kaduna State, where judges of the Election Petitions Tribunal held divergent views on the outcome of the 18th of March governorship election. The lead judge ruled in favor of the All Progressives Congress, dismissing the petition filed by the People's Democratic Party and its candidate Isa Ashiru. Two of the three tribunal judges found that the preliminary notice was filed out of time, deeming it abandoned. Also, two of the three judges declared the election inconclusive, citing an imbalance between the number of permanent voter cards received and the lead margin of more than 10,500 votes. The two judges ordered a rerun in 22 polling units across 4 local government areas to be completed within 90 days.
They are required to also consider the petition on merit. So on merit, 2 of them said that election is supposed to be conducted in 22 polling units because the number of the voters there exceed the margin of lead. But they have said that the PDP wanted it to be declared as the winner of the election. The tribunal said that they have no proof that. They allege that there are corrupt practices perpetrated by APC. They said they have no proof that. So in essence, as of today, the PDP petition is dismissed by the tribunal. Unless PDP appeal to the Court of Appeal, then we now know what will happen there. But the petition has been dismissed.
Yeah, the court has delivered judgment directing that the election in Kaduna State is inconclusive. And there should be rerunning elections in about 4 local governments, somewhat in 4 local governments.
So how many polling units and how many registered voters are we looking at?
Well, that we'll have to look at the details. Well, it's in 4 local governments, about 14 wards or so.
So why did the tribunal decided on this inconclusive election?
Why the tribunal decided what it decided? It's based on the facts placed before it. Court arrived at a decision based on the submissions and argument of lawyers, and the majority of the tribunal judges decided that the election was inconclusive, and 1 judge affirmed the election. And the majority decision of the court is that the election was inconclusive.
Meanwhile, the People's Democratic Party in Kaduna State has announced it will be appealing the tribunal judgment until justice is served. Let's now talk to a legal practitioner to better understand what happened in court earlier today. Liborous Oshoma joins us on the news at 10. Thank you for joining us this hour. Help us understand.
Yeah, thank you, Nifemi.
In clear terms and plain language, if you can, without the legal jargons, what your interpretation of today's judgment really is?
What the judgment of today is that the petition has been dismissed by the tribunal. I have seen a lot of misleading headlines. The tribunal order a rerun. That is not the case. Let me break it down so that people will understand in clear terms. By the rules, by the Electoral Act, by the rules of the rules of practice of election petition tribunals, once you file your petition within 21 days, there's what we call pre-action notice. Pre-hearing notice. You must file your pre-hearing notice, I think, within 14 days or so after filing your petition. If you fail to file the pre-hearing notice, that petition is deemed abandoned. Failure to file, even though the petition had been filed, failure to file your pre-hearing notice within time, we presume that you have abandoned your petition. So in this case, the court is saying that, look, you abandon your petition because you file your pre-hearing notice outside the statutory time for filing of notice. But because we are required to hear the petition, even though we have dismissed the petition, but assuming the Court of Appeal says we are wrong in dismissing it, that you should have also gone ahead to hear the body of the petition, if we had heard the petition, our order would have been that the election is inconclusive because election did not hold in certain areas. And the number of registered voters in those areas is more than the number or the margin of leads. So it is not that the petition, the tribunal ordered a rerun. No. What the tribunal simply did is that we have dismissed the petition, but assuming the Court of Appeal says we are wrong in dismissing it, instead of taking back the petition to the trial court to say, go and rehear it, we are now hearing it. We have heard it, and we say that there was election, there was no election in some polling units.
So it would seem that
that is the judgment of the.
I hear you. It will seem that the APC is killed through this time based on technicalities, their preliminary objection that you mentioned earlier. But then we all now saw that the court still went ahead to decide the petition on merit, which according to you might have been an academic exercise. Is that right?
No, yes, ordinarily it would be an academic exercise, but it is not an academic exercise because now, unlike before, do you know that the petition will not even get to this stage? If it were before, at the preliminary stage, this petition ought to have been dismissed long ago. But because the courts now are enjoined to take preliminary objection and the main petition and then deliver judgment at the end, at the tail end. Let me give you an example. You saw at the Presidential Election Petition Tribunal, the court, after dismissing some witnesses, they said this witness statement was not filed alongside the petition. They dismissed those witnesses, discountenanced the evidence that they gave and the documents submitted. They still went further to consider those witnesses and say, okay, look, we have dismissed them all, but assuming we did not dismiss them, let us now consider them on the merit. They considered them and still went ahead and said it was not substantial enough. So in this case, what the tribunal do, what they do is they take preliminary objection, preliminary matters, and then reserve judgment of the preliminary issues with alongside the main issue. So now the judge has said, you did not file your pre-hearing notice within the time required for filing it. So your petition is abandoned. It is dead on arrival. So that petition is struck out. But assuming we now, because ordinarily, if it's a civil case, you go on appeal and the court says, no, you ought not to have struck out. Take it back to the trial court to hear. So because of time, the Court of Appeal would not say take it back because there is no time. They say, okay, now let us consider the petition on its merit.
I get you.
If we had considered it,
yes.
That's
I get you quite clearly,
so
Mr. Oshoma.
You take the first judgment.
Yes.
You take the first judgment. That is the main judgment in the matter. The other one is just, an exercise in case what the Yorubas will call Ijeyoje. This one no enter. This one supposed
so
that's what it
the
means.
PDP now says that it's going to appeal. I spoke with the counsel to the APC earlier that mentioned that they were not going to appeal this decision. What they can do is cross-appeal if the PDP heads to court. But based on your experience, at the Court of Appeal, what are the chances that beyond the dismissal that we saw at the tribunal, that the higher court is going to consider the merit of this case?
Look, Nifemi, these issues, these election petitions are time-bound. Once you're out of time, you're out of time. It's like filing a petition outside 21 days. And the court says, well, this petition is dead. You have filed it out of 21 days. But because the petition is already with us, there is no way we cannot hear it. We will still hear it and make an order, but it is filed outside 21 days. So that means the petition is dead. So if the PDP certainly will appeal, even though they are saying, the court said order a rerun. If the court had given you, order a rerun for you, why are you appealing? The court had, they certainly they will appeal. And when they appeal, the APC is also going to cross appeal. Because the APC now would be saying that the court had no business still going further to hear the matter on the merit.
All right.
since it has dismissed the petition, in its entirety, haven't, abandoned the petition at the preliminary stage. So there are going to be cross appeal on both sides. But I can tell you that if it is time bound, certainly the Court of Appeal will look at the time. If it is out of time, it is out of time.
Well, you know what they say? The law is, in the case where the timing of filing now decides, irrespective of the merit. Liborous Oshoma, thank you so much for shedding light on this issue.
Always my pleasure.